Okay, let's dive in. Picture this. Maybe a patient, near the end, confessing to a murder they got away with years ago. It's shocking, right?
A huge revelation, yeah. Changes everything you thought you knew.
Exactly. But today, we're looking at a different kind of confession, maybe with even bigger ripples. Not in a hospital, but a Hong Kong courtroom back in the early 2000s. A massive fraud trial.
And the confession, so to speak, it didn't come from the person on trial.
No. It came from the prosecution's star expert witness, a failure to disclose something crucial. And it just threw the whole case, the whole legal process, into total chaos.
So we're not talking about one hidden death, but something that could potentially shake trust in the financial markets, or at least the course of justice in this specific, very significant case.
And what's really grabbed me about this, looking through the materials, is that it wasn't just, an accident. Oops, I forgot. The allegations that came later suggest, well, maybe an attempt to manipulate the whole system.
A serious charge.
Definitely. So for this deep dive, we've got this listener-submitted stack of legal documents. It's all centered on HKSR v. Zhang San, a Hong Kong Court of Final Appeal case from 2003.
A really fascinating one. Lots of layers.
Think of this as your shortcut through the legal maze. We're aiming to pull out the key bits, explain what went down, and why it actually matters. No need to read hundreds of pages of judgments where we're getting to the core.
Right. And to get why this non-disclosure was such a big deal, we kind of needed to rewind a bit, set the scene with the original case.
Good idea. So the criminal charges were against Zhang San. He was the chairman, major shareholder of a company called the United Group, and also Shizarui, the finance director.
And the charges were serious. Conspiracy to defraud, false accounting, it all circled around several big share issues by United Group back in the early 90s. Involved a couple of related companies too, United East Glory and United Properties.
So United Group is issuing shares, trying to raise money, supposedly, but the prosecution's argument was that the buyers, these independent investors, well, they weren't independent. Not really.
That was the nub of it. The claim was these investors were actually front companies, secretly controlled by Zhang San.
And crucially,
no real money changed hands, or at least that was the allegation for these specific transactions. It wasn't about missing money exactly, but about puffing up the company's image, making it look stronger than it was.
Like building a house of cards, financially speaking, it looks solid, but there's nothing really holding it up if you push.
And this alleged lack of actual cash coming in was supposedly hidden, covered up by some pretty complex accounting involving First South China Bank, FSCB, and another entity, Prudential, out in the Cook Islands.
Right. It sounds like, shuffling shells, moving money around internally, perhaps, maybe using FSCB somehow to make it look like external funds were coming in, creating this false picture that United Group had lots of cash in the bank.
Exactly. And the person who was supposed to untangle all this for the prosecution was Li Guorong, a forensic accountant.
He was brought in quite early, wasn't he, back in '93?
Yeah, appointed to specifically review these share deals. He produced this big expert report in 1997.
And that report, plus his testimony later in court, that was basically the prosecution's anchor, their main evidence.
Absolutely vital. And importantly, the defense team got this report way before the trial. They knew what his findings were, his analysis. No surprises there initially.
Okay, so fast forward. The first trial gets going in 2001. Judge Sun Goji is presiding.
And Li Guorong, the expert, he takes the stand. It's actually pretty deep into the trial already, day 53.
Now, here's where things take a sharp turn. The defense strategy, interestingly, wasn't really to argue about the transactions themselves. They didn't even fight much about the, let's call them accounting irregularities, Li Guorong pointed out.
No, their whole focus was on Zhang San, the chairman. Did he know? Was he involved? It was all about his knowledge, his intent. Could they prove he was aware of any fraud?
Makes sense. Plausible deniability, perhaps. But then the defense drops a bomb.
They reveal that Li Guorong, this key prosecution expert, he was also a director at another company, Guangdong Keelon Electrical Holdings.
And this wasn't just some small, irrelevant company. Guangdong Keelon was listed, right? Hong Kong and Shenzhen?
Correct. And not just listed, but under investigation itself. For some pretty serious issues, undisclosed related party transactions, big financial losses.
Wow. And the kicker, Li Guorong had recently resigned from their board.
Talk about pulling the rug out. This wasn't just a minor detail. It goes straight to the expert's credibility, doesn't it? His duty to be impartial, transparent.
Absolutely. The fallout was immediate. That first jury dismissed. They had to be.
Yeah, the trial collapses, essentially, and the whole focus suddenly shifts. Why didn't Li Guorong mention Guangdong Keelon? especially given it was facing its own financial scrutiny.
This whole mess then leads Zhang San's lawyers to try again to get the case thrown out. A second application for a permanent stay of proceedings.
And this time, it wasn't just about the Guangdong Keelon issue. They added something else, another layer involving Li Guorong.
Right. They broadened the argument. Still abusive process, they claimed, but now related to both Guangdong Keelon and Li Guorong's involvement with a different company, Jindan Group Holdings, also known as Golden Shield.
So, building on the chaos from the Keelon revelation, they bring in Golden Shield. And this Golden Shield part is where we're really focusing our deep dive today.
Exactly, because the allegation here was incredibly serious. It wasn't just about Li Guorong anymore, but about the actions of the regulator, the Securities and Features Commission, the Wealth-U.
The claim was that the Jin deliberately shut down an inquiry they had started into Li Guorong's conduct regarding Golden Shield.
And why would they allegedly do that? To protect him, to keep his credibility intact so he could continue to be the star witness against Zhang Sen in that massive fraud trial.
A huge allegation,
Yeah.
essentially accusing the regulator of interfering with justice to secure a conviction.
This is where that initial hook, the patient confessing to murder, really clicks for me. It's not a literal death, but the potential death of the prosecution's case, possibly caused by the expert's own hidden issues, and maybe even, allegedly, aided by the regulator trying to keep those issues buried. The potential death of a fair trial process.
It's a tangled web, all right. So let's dig into the Golden Shield specifics and what the defense and the THECO actually argued about it.
Okay, so let's recap that core conflict around Golden Shield. The defense is basically saying, look, this was a serious abusive process.
Their argument was the Neknu Li Guorong was their key witness against Zhang San. They also had this separate inquiry going into his conduct related to Golden Shield, and the defense alleged they deliberately terminated that Golden Shield inquiry.
Not because there was nothing there, but specifically to shield Li Guorong, to make sure nothing damaging about him surfaced that could undermine his testimony in the Zhang San trial.
Which, they argued, messed with the whole system. It deprives Zhang San of his right to know about all relevant information, especially information that might impact the credibility of a crucial prosecution witness. That's fundamental common law disclosure, right? Fair trial stuff.
Absolutely fundamental. But of course, there are two sides. The U had its own explanation for why it closed the Golden Shield inquiry into Li Guorong. We see their arguments laid out in the Court of Final Appeal documents.
They basically said they acted reasonably, given what they knew at the time, given their resources. They mentioned having a heavy workload in their disciplinary division.
And they also pointed out, look, we did take action in the Golden Shield matter, just not against Li Guorong. They went after someone else, Mrs. Ushiming, who they seem to view as the main person responsible there.
Right. Their position on Li Guorong specifically was essentially that after looking into it, they judged that pushing the inquiry further probably wouldn't turn up anything significant enough to warrant disciplinary action against him.
Especially, perhaps, when compared to the action they were already taking against Mrs. Yu. They framed it as a sort of resource allocation decision based on likely outcomes.
Which, puts us right in the middle of a really tricky ethical and procedural minefield.
Totally. On one hand, what are the disclosure duties of an expert witness? How much about their professional life, past or present, is actually relevant? Where's the line?
And on the other hand, what about the regulators, the AJ here? How do they balance investigating potential wrongdoing with, well, ensuring they don't inadvertently sabotage or unfairly influence a major criminal trial? Especially when the person they're investigating is also a witness for the prosecution side they work closely with.
It's a real balancing act. Potential conflicts of interest abound.
And the Court of Final Appeal, Hong Kong's highest court, they really had to wrestle with all this. Reading through their judgment, it's clear they didn't take it lightly.
No, they went deep. Really meticulously reviewed what the trial judge had found, looked hard at the evidence about the DIO's decision-making process regarding Golden Shield, without spoiling the final outcome of the appeal.
It was definitely a complex decision, weighing up whether the trial judge was right to grant that permanent stay based on the Golden Shield issue.
It really forces you, the listener, to think, doesn't it?
Yeah.
Looking at this chain of events, the initial trial, the Keelon bombshell, then the Golden Shield allegations against the data, what stands out to you?
Yeah, were the DIO's actions closing that inquiry justifiable?
Right.
Was it a reasonable exercise of discretion, given their workload and their assessment of the case, as they claimed? Or did it cross a line? Did it unfairly disadvantage Shangsan?
And how much checking should be done on expert witnesses? Should their entire professional history be fair game if there's even a whiff of a potential conflict or past issue? Where do you draw that line to ensure fairness but also practicality?
It's definitely a case that invites debate. If you're interested, digging into the public records on HKSOR v. Zhang San could offer even more detail. We'd genuinely be interested in hearing different perspectives on these dilemmas.
Because it's not just about this one case from 20 years ago. It touches on really fundamental stuff. The integrity of experts, the power dynamics in big legal fights, the role of regulators.
Yeah, these questions are always relevant.
So maybe a final thought to leave you with, drawing from this deep dive. This case is such a stark reminder, isn't it, that even when you have these incredibly detailed investigations, complex legal arguments, everything can still get sideswiped, potentially derailed by shadows, by information that wasn't disclosed.
The confession that wasn't made up front.
Right. And the big question it leaves hanging is, how do we make sure we have transparency? How do we ensure accountability, really, at every step to stop these kinds of confessions from shaking the very foundations of the legal system itself?